Hi, it's Mike DelSignore. In today's video, I want to talk about how long does it take to resolve an OUI case. It's one of the more common questions people have. They want to know, when's this process going to end? You're arrested for OUI likely over the weekend, and you're upset, you're angry, and you want to know basically, when is this going to end? When are you going to have a resolution in the case? Well, it's going to depend. If you want to fight the case, take it to trial, and be found not guilty, it's going to take, depending on the court, probably anywhere from a low of 4 or 5 months to 9 months to even longer sometimes, depending on the court. If you want to resolve the case, typically that can be done very quickly. The issue will be whether you get your license back. If it's your first offense, it's the easiest to get your license back. If you took a breath test, was over the legal limit, and you resolve the case within the 30 days, your 30-day suspension will end right there. A 45-day suspension will start. While you might want to resolve the case quickly, it's important to make sure you're doing the right thing for your long-term future. In other words, while it might be easy to resolve the case, plea out, and do probation, because it's not that onerous. You have to do a 40-hour course, an alcohol education course. You're going to have an OUI in your record, and that may have some long-term implications. The other reason why you might want to consider fighting the case is these are generally very winnable cases. In other words, this week I had 2 clients found not guilty of OUIs. Last week I had other clients who've had a lot of success over my career and especially a lot of wins lately on these cases, because what they come down to is the opinion of the officer determining whether that opinion is enough to say beyond a reasonable doubt that you were under the influence. And a lot of times there's just not enough evidence to make that call. Judges are very good in Massachusetts. They have a really good standard of reasonable doubt. Juries tend to understand too that it's not enough just to say you had some alcohol, that you're impaired. They have to prove that your ability to drive was diminished by alcohol. It's not illegal to consume alcohol and drive. So as everyone knows, you can go out and you can have some drinks and drive, just you can't have too many of them. So where that line is can be difficult to draw. Now, when I look at these cases, I look at the driving, the field sobriety test, your conduct at booking, and I look at it not to say I'm going to contradict everything in the report or there won't be any weaknesses in our argument, but to find where I can say that there's reasonable doubt, where basically the best part of the case is. Is it the driving? Is it the field test? Is it you polite, cooperative? Is it medical records? What theme can we have? Obviously, in the case, I had a trial today. The driving wasn't awful. It wasn't great. It was definitely more helpful for the government, but the field tests were pretty good. When I broke them down, I was able to show that the officer really didn't see many of the clues he's trained to look for. The clues the officer saw were relatively minor, and the major indicators weren't there. The client maintained heel to toe, stayed in a straight line, made the turn on the 9-step walk and turn. So I asked the officer, I said, these tests are designed to sort of simulate driving. The idea of these tests is that as best we can, we're trying to recreate driving, where driving involves mental and physical tasks being done at the same time. And that with the idea behind the field sobriety test is it's creating a similar situation to driving. So the fact that my client could remember the turn, he could process instructions, he physically performed the turn, shows that he had mental ability, physical ability, which means that he had that ability to drive, or at least means that it's not so clear he didn't. He was able to stay in the start position without losing his balance. So that all shows somebody has good both mental and physical skills, and that's what we're trying to articulate to a judge or jury, that this person was alert, coherent. They weren't stumbling. That they were able to move about, think, act, and had the physical capabilities to drive. And sometimes we talk about how somebody provides a license and registration. Officers are taught that sometimes someone impaired won't be able to retrieve their license and registration without any difficulty. So when you consider whether you want to resolve the case, don't just think about the time. Think about long-term implications. Make sure you understand the defenses to these cases. Time can vary. In other words, some courts move cases very quickly. If you're in Worcester County, the cases tend to move faster. Other counties, they like Rentham, the cases tend to take a little longer there. So it really depends on, is the court a court where you could do a trial with a judge? If you can do a bench trial, the cases tend to move faster. If you're in a court where you have to do a jury trial, often those cases take longer because most courts can only do one jury a day. So there's going to be other cases there, and sometimes you'll get what they call bumped or continued, meaning that it's too much on the court schedule, too many cases for that day, and things will get continued for what they call court congestion. So there's a lot of factors that can impact how long the case takes. But I'm aware of that, and I know people don't want this to drag on. If we're going to resolve it, if it looks like the case isn't going anywhere, I tell someone right away. Sometimes I say, you know what, you should resolve this case. If I say that, basically you should resolve the case. That's typically there's no way the case can be won, or it's very unlikely. A lot of cases, they're in a gray area, but I still try to say what I think needs to happen, why I think the case could be won, why it might not be won. And then ultimately it's up to you to make the call as to whether you want to put this behind you or whether you want to fight it. That's an individual decision. There's a lot that goes into that, but I'll help you make that decision. I understand people want certainty, want to move on with their life, but I also have a passion to help people avoid an OUI conviction. That's my hope for you, is that I'll be able to get you a not guilty verdict. Call, text anytime if you have questions, 781-686-5924. My name is Mike DelSignore. My passion is helping people charged with OUI avoid an OUI conviction, and I handle cases every day in courts throughout Massachusetts.